Good evening, ladies and gentlemen. We meet today on the lands of the Wurundjeri people of the Kulin Nation, and I pay my respects to their elders, past and present, and indeed to any Indigenous persons gathered with us this evening. My name is Pip Nicholson. I'm the Dean of the Melbourne Law School, and it is my great pleasure to welcome you all here on a sunny, balmy, pleasant Friday evening to listen to some wisdom from the Chief Justice of Australia. So, good evening, Chief Justice, distinguished guests, ladies and gentlemen. Sit back, relax, and let's enjoy a very interesting conversation this evening. I would like to commence with an acknowledgement of the work of the Centre for Corporate Law and Securities Regulation, who were our agents and envoys in arranging for the Chief Justice to meet with us tonight to talk about judicial advice to trustees, its origins, purposes and nature. I would also like to thank the sponsor for this evening's talk, Clayton Utes, for their generous support. Tonight's event forms part of the annual Harold Ford Memorial Lecture Series, named in honour of the Melbourne Law School's distinguished alumnus, Professor Harold Ford, who passed away in September 2012. Professor Ford spent almost his entire career at the Melbourne Law School, following his appointment to it in 1949. He was the Dean of the Law School in 1964, the year in which I was born. I was provoked to think about today. And then again from 1967 until 1973. He is remembered by all those who knew him and those who know his legacy as a gifted teacher. He was also a formidable scholar. Professor Ford made many important contributions to law reform and co-authored a number of very influential texts, including a leading text entitled Principles of the Law of Trusts. The Harold Ford Memorial Lecture celebrates the many contributions of Professor Ford to Melbourne, the law school, its students and legal scholarship. And it is a fitting testimony to his legacy that we have an address by the Chief Justice tonight on the topic of trusts. Let me now turn to the Chief Justice. Chief Justice Kiefel was admitted to the Queensland Bar in 1975 and was the first woman in Queensland to be appointed Queen's Counsel in 1987. She was appointed Justice of the Supreme Court in 1993 and in 1994 was appointed to the Federal Court. The Chief Justice has also held a commission as the Justice of the Supreme Court of Norfolk Island from 2004 and has served as a part-time Commissioner of the Australian Law Reform Commission. Chief Justice Kiefel was appointed as a Justice of the High Court of Australia in September 2007 and in January 2017 was appointed its Chief Justice. In 2013, she was elected a titular member of the International Academy of Comparative Law and in 2014 was elected as an honorary bencher of the Honourable Society of Gray's Inn. In 2011, Chief Justice Kiefel was awarded a companion in the General Division of the Order of Australia for eminent service to the law and to the judiciary, to law reform and to legal education in the area of ethics, justice and governance. We are indeed grateful to the Chief Justice for travelling from Canberra to Melbourne to be with us tonight and for kindly agreeing to deliver this year's Harold Ford Memorial Lecture and share her wealth of knowledge on the law of trusts. We hope you enjoy the evening and welcome. Thank you very much, Chief Justice.
Thank you, Professor Nicholson. I'm honoured to present this lecture, which is given annually in recognition of the significant contribution made by Professor Harold Ford to legal education and scholarship in Australia, particularly in the areas of corporate law and trusts law. In the foreword to the book of essays, which was published in his honour around the time of his 80th birthday, my former colleague Kenneth Hayne said of Professor Ford that, quote, all of his work has been marked by the restless questioning and intellectual rigour of the scholar. It has been the measured, incisive, and above all, deeply considered contribution to the fundamental consideration of principle which has marked his work. Few in Australia have made the contribution to legal scholarship that he has made over so many years. My discussion this evening concerns what some might think is a rather curious practice, whereby judges give advice to a trustee on matters concerning the administration of a trust estate or the interpretation of trust instruments. This does not sound like the work in which courts are usually engaged, but it has a very long history. The origins of this jurisdiction appear to be the adoption, at least from the early 14th century, of the fiefament to usus, the ancestor of the modern trust with respect to land. The use was adopted in particular to evade the common law rule which prohibited devisers of freehold land. The holder of freehold land, the fio for, would by this means convey land during his lifetime to fiefes to uses. They in turn held it for the fiefo or a third party, the setiki use, under instructions to convey the land to persons named in the fiofor's will. The common law courts recognised only ownership of property. They would neither enforce nor interpret a use except in special circumstances. There therefore came to be widespread adoption of uses with respect to land. By the time that Chancery's jurisdiction over uses was established, the greater part of the lands in England are said to have been held by fiefes in trust. However, this was not until the middle of the 15th century. A question which then arises is how uses could have existed in the interim without judicial support. The answer suggested by one legal historian today is that they were enforced by the ecclesiastical courts, as Maitland himself had said. They were considered to fall within the Church's probate jurisdiction, but there were limits to the extent to which ecclesiastical courts would enforce provisions for a testator's estate, and as a result the parties turned to the Chancery courts, which began to entertain applications for the enforcement of uses as a matter of conscience. By the 19th century, the supervisory jurisdiction of the courts was well established, and suits for the administration of trusts were commonplace. At this time, Story noted, but did not identify the origins of, the practice of executors or administrators applying for aid and relief in the administration of estates when they could not safely administer the estate except under the direction of a court of equity. Lord Redesdale said that the jurisdiction of courts of equity in the administration of assets is founded on the principle that it is the duty of the court to enforce the execution of trusts. Lord Chancellor Eldon likewise said that the execution of a trust shall be under the control of the court. Such was the control of the equity courts by the mid-19th century that if a beneficiary asked for general administration, it would be ordered as a matter of course. The court would order that the trust be specifically performed under its supervision. In 1862, a commentator observed that the jurisdiction of the Court of Chancery over trusts has always, both in principle and in fact, implied and been accompanied by an administrative practice and procedure, which seems to flow at once and of necessity from any assumption at all by the court of a power to establish or enforce the fiduciary obligation. The administrative jurisdiction of which this author speaks is defined as that branch of the jurisdiction which has to adjust and execute doubtful or recognised rights rather than to decide between directly hostile litigants. By this time, however, the administration action had become a cumbersome and expensive exercise which required all interested parties to be brought before the court and the taking of accounts and inquiries. Charles Dickens' description of the suit Jarndyce and Jarndyce is indicative of how it had come to be viewed by the public. Moreover, much of what was involved in the supervised performance of a trust by the court was unnecessary, where all that was in question was the construction of the trust instrument, or what should be done in the management and administration of the trust estates in the particular circumstances. But to obtain practical advice of this kind, a trustee would have to commence an administration suit, raise the particular point in the pleadings, obtain a direction or advice on it, and then stay further proceedings in the action. There was no alternative process by which a trustee could seek judicial advice on specific questions until Lord St Leonards, who had been appointed Lord Chancellor in 1852, proposed a statute which permitted trustees to file an application for the opinion, advice or direction of a judge on isolated questions relating to the administration of trusts. Section 30 of the Law of Property Amendment Act of 1859, otherwise known as the Lord St Leonards Act, provided an indemnity to a trustee who acted on that advice. The statutory indemnity provided by the Act was conceived of because it was recognised that the burdens of a trustee could be onerous and the office was usually gratuitous. Lord St Leonards Act was later repealed after new procedures were provided for by the rules of the Supreme Court in England in 1883. They enabled questions to be determined with even greater facility and economy. The purpose of the new Order 55 Rule 3 remained the same: to provide an alternative to the general administration suit. English cases decided following the making of the rule make it clear that the jurisdiction conferred by the rule related to questions that could have been determined in an administration action. The Australian colonies followed suit, both with respect to enacting Section 30 of the Lord St Leonards Act and introducing rules of court. Some states and territories later passed legislation which extended the jurisdiction of the courts in relation to the directions which might be given. The current position is not uniform. While Victoria, Tasmania and the Northern Territory have followed the English approach of retaining only rules derived from Order 55 Rule 3, in New South Wales, the Australian Capital Territory, South Australia and Western Australia, there are both statutory procedures for seeking a judicial opinion, advice or directions, and procedures under court rules for seeking the determination of questions which could have been determined in administration proceedings. Queensland has only a statutory procedure. Generally speaking, there may not be much of a difference in practice. In the Macedonian Orthodox Church case, which was decided by the High Court in 2008, it was said of the dual system retained in New South Wales that the judicial advice facility and the originating summons facility were treated as serving the same function, and that principles derived from one may be useful to the exercise of powers under the other. The statutory provisions and court procedures relating to advice given by the courts to trustees have as their aim efficiency in the administration of the estate and the reduction of costs. It was said in the Macedonian Orthodox Church case that there are two purposes of the power or jurisdiction exercised by the courts in this regard. The first accords with the purpose of a general administration suit, namely the protection of the trust and its interests. This has always been the concern of courts of equity. The second is the protection of the trustee. It recognises the fact that a trustee is usually entitled to an indemnity for all costs and expenses properly incurred. The principal two purposes referred to are interconnected. The interests of the trust are protected by removing the concern of a trustee about his or her exposure beyond her or his indemnity. It was explained in the Macedonian Orthodox Church case that judicial advice, there it was about litigation, protects both the trustee and the trust by ensuring that the interests of the trust will not be subordinated to the trustee's fear of personal liability for costs. It follows from these purposes that a trustee who is sued should take no step in defence of a suit without first seeking judicial advice about whether it is proper to defend the proceedings. In re Beddo is authority for the view that an application can and should be brought to the court to authorise the commencement or defence of an action. The warning of Lord Justice Lindley in that case, that a trustee who fails to seek the sanction of the court before doing so may not be protected, has become very influential. The High Court has emphasised the importance of a trustee in doubt as to the correct course of action seeking judicial direction. In Partridge and Equity Trustees, Executors and Agency Company Limited, the executor and trustee of a testator's estate failed to insist upon payment of instalments due from a debtor company, which later went into liquidation, with the result that the debt was lost to the estate. The court held that the trustee should not be relieved of liability under a provision of the Trustee Act 1928 Victoria, which permitted the court to excuse a trustee from omitting to seek directions from the court and relieve him wholly or partly from liability where he had acted honestly and reasonably. The court said that as such a large amount was at stake, it could not be said that the trustee acted reasonably in failing to seek directions from the court. In Marley and Mutual Security Merchant Bank and Trust Co., a case involving the estate of the late great reggae artist Bob Marley, the Privy Council pointed out that in exercising its jurisdiction to give advice to trustees, the court is engaged in determining what is in the best interests of the trust estate. It is not engaged in determining the rights of adversarial parties. It will be recalled that the same observation was made with respect to the powers of the Court of Chancery in administration suits, and it accords with what was said in the Macedonian Orthodox Church case. Rather, proceedings for judicial advice operate as an exception to the court's ordinary function of deciding disputes between competing litigants. They afford a facility for private advice for the personal protection of the trustee. Judicial advice about whether a trustee should commence or defend proceedings is not to be confused with deciding the issues which are in contest in proceedings between the trustee and others relating to the trust. The issue for a judge with respect to judicial advice is whether it would be proper for a trustee to commence or defend the proceedings. Judicial advice proceedings are not a trial of the issues in question. In the Macedonian Orthodox Church case, the appellant applied for judicial advice under Section 63 of the New South Wales Trustee Act as to whether it would be justified in defending proceedings brought against it, seeking its removal as trustee on the basis that it had contravened the doctrine and law of the Church in dismissing the second respondent as parish priest, and had acted in breach of trust in various ways. The judge at first instance answered the questions affirmatively, but the Court of Appeal reversed that decision on the basis that it was generally inappropriate for the court to give judicial advice respecting adversarial proceedings. On appeal, the High Court restored the orders of the primary judge. A number of points were made in the joint judgment about the nature and extent of the advice which might be given. It was said that there is no limitation in relation to the power of the court to give advice. It is certainly not limited to non-adversarial proceedings. The only jurisdictional bar is that an applicant must point to the existence of a question respecting the management or administration of the trust property, or a question respecting the interpretation of the trust instrument. The summary character of the procedure indicates a wider rather than a narrower operation for the legislative provision, but this will tend to vary according to the terms of the trust involved. Judicial advice is not limited to questions about whether proceedings should be brought or defended. The questions about which advice may be sought are limited only to those which might arise in a general administration suit. In practice, advice is commonly sought with respect to questions involving the administration of a trust estate, for example, whether an asset should be sold, or as to the interpretation of the terms of the trust, including as to the trustee's powers. Although the power to give advice is wide, it is nevertheless limited to its purposes, namely to protect the trust estate and the trustee. An application for judicial advice is not a vehicle for the attainment of other purposes. The recent decision of the High Court in Federal Commissioner of Taxation and Thomas confirms this limitation. In that case, the trustee sought directions as to the construction of resolutions concerning the distribution of income from the trust. The construction which might be given had taxation implications for the beneficiaries. The Commissioner of Taxation was given notice of the proceedings, but he took the view that he was neither a necessary nor an appropriate party to the application. The primary judge gave reasons on the question of construction, but instead of making orders in terms that the trustee could act on the basis of that construction, the judge was persuaded to make declarations to the effect that the resolutions were effective to confer certain interests and that income had been distributed by the trustee in accordance with those resolutions. The declarations were necessarily based upon and carried into effect a view of the operation of the taxation legislation. On the Commissioner's appeal to the High Court, the trustee relied on the decision in Executor Trustee and Agency Company of South Australia against Deputy Federal Commissioner of Taxes as binding the Commissioner to the declarations. In that case, the orders of the court, made on the trustee's application for directions, defined the interests of the beneficiaries in land the subject of the trust. The orders were made in proceedings to which the beneficiaries were parties. In later proceedings between the trustee and the Commissioner, it was held that the Commissioner was obliged to act on the basis of the interests as declared by the court. The trustee's argument in Thomas's case was that the Commissioner was likewise bound. It was rejected. It was explained that the Executor Trustee case is authority only for the proposition that the general law rights of trustee and beneficiary inter se are defined also as against the Commissioner. More relevantly for present purposes, it was pointed out that decisions made under the judicial directions power cannot bind the Commissioner in the application of taxation laws. That is because it is no part of such an application for the court to decide how taxing acts operate. The function of the judge is only to provide advice respecting the management and administration of the trust in order to protect the trustee. The decision in Thomas' case points up a number of issues concerning the nature of judicial advice of this kind. It will rarely be appropriate to make a declaration because the rights of the parties will not be a matter upon which the advice is to be sought. The advice is in the nature of private advice to the trustee. This follows from it being a purpose of the advice given to provide personal protection to the trustee, and also from the nature of the jurisdiction, which is supervisory and administrative. These features may be seen from the terms of the advice given, which is usually in terms that it would be appropriate or in order for the trustee to do something, or that she or he would be justified in taking a course of action. Consistently with its historical origins, the advice is concerned not with purely legalistic matters, but with the propriety of a course of action, one which accords with good conscience. The advice is not given in proceedings inter partes. The proceeding is brought ex parte by the trustee for advice to be given to the trustee. Two consequences follow from this. The first is that the trustee is under the same duty as any applicant ex parte to the court to make full disclosure of all relevant matters, including the limits of the trustee's powers. The second is that even if persons who might be interested in the advice, or indeed whether it should be given, are given notice of the application, they are not strictly parties to the proceedings unless the statute or rule provides otherwise. In Marley's case, Lord Oliver said that the court would of course be interested to hear whether any objections had substance, but the court was not obliged to give them particular weight. The Macedonian Orthodox Church case left open the question whether and to what extent the inherent jurisdiction of a court of equity may explain the jurisdiction to give judicial advice. It was not necessary to the decision in that case, which concerned an application under the New South Wales Trustee Act. It may be observed, though, that the American restatement of the law of trusts clearly views the power to give advice as inhering in the equitable powers of courts having jurisdiction over trusts. It is pointed out that although general administration of trusts is rarely sought today, it provides essential evidence for the historical basis and theoretical nature of the supervisory jurisdiction over trust administration. This may be taken to imply that the jurisdiction still exists, even though it is not utilised, and that may be so regardless of the statutes or rules of court which provide a more expeditious procedure. The general administration suit may have been the reason for the development of these procedures, but that they did not remove or supplant the jurisdiction of the courts with respect to the administration of trusts. Of course, what is necessary for jurisdiction may not be sufficient to enliven the judicial power of the Commonwealth. Jurisdiction, in the sense of a court's authority to decide, and judicial power are quite different concepts. Questions concerning whether it is an exercise of judicial power by Chapter 3 courts to give advice of this kind have rarely arisen. It might be thought that judicial advice of this kind most closely resembles an advisory opinion, which would exclude it from judicial power. In some recent decisions, mostly I think in the Federal Court and one Supreme Court, it has been pointed out by reference to Melifont's case that the advisory opinion which was said in Re Judiciary and Navigations Act not to involve the exercise of judicial power was purely academic and responsive to an abstract question, distinguishing it from judicial advice of the kind here in question. But it should also be observed that in Melifont's case, the court went on to explain that the opinion in Re Judiciary and Navigation Acts was hypothetical, in that it was unrelated to any controversy between the parties. And the same might be said of advice to trustees, so the answer might not lie here at all. In the King against Davison, Chief Justice Dixon and Justice McTiernan acknowledged that many of the various elements upon which the definitions of judicial power insist are not present in the case of many orders made by the Courts of Chancery, including those made in the administration of trusts. It is true that orders in the nature of judicial advice do not determine rights. There is no question of a power to give a binding and authoritative decision, and the parties do not submit a list for adjudication. It may also be said that a cause of action is largely a common law concept, not truly referable to proceedings in equity, and equity's concern to provide a remedy to meet the circumstances of a case falling within its jurisdiction. In Davison's case, their honours said that despite lacking what is said to be necessary to judicial power, it has long fallen to the courts of justice to make many orders, an example of which is the grant of probate of a will, as it is with judicial advice. It was said that that is clearly a judicial function and could not be excluded from the judicial power of a country governed by English law. It may therefore be inferred that their honours regarded orders by way of advice to trustees as the exercise of judicial power. As is often the case with judgments written by Justice Dixon, it is perhaps less clear whether his conclusion is based upon a view of judicial power as an historical anomaly or as an exception. In the course of the discussion which followed what I have referred to in Davison's case as to the distinction between legislative and judicial power, the honours referred seemingly with approval to the thesis of Dean Pound. The thesis is that in all cases of judicial power, it is preferable to place more reliance on history than upon juristic analysis. Thank you for your attention.
Well, I'm very honoured to have been asked to propose the vote of thanks to the Chief Justice for Her Honour's most insightful and illuminating presentation this evening. I'm sure you'll agree that the Chief Justice achieved the impressive feat of presenting both enlightening and accessible fare for a Friday evening. In particular, we're indebted to Her Honour for explaining the historical roots of what appears to be a curious practice by modern standards, via a colourful journey from the 15th century, replete with Dickensian quotes and characters as diverse as Lord Linley and Bob Marley. Her Honour also provided some rich food for thought in relation to the interplay between the supervisory jurisdiction in respect of the administration of trusts and the concept of judicial power. Given the demands on Your Honour's time, your presence here this evening is enormously appreciated, both in itself and also as a tribute to the late and great Professor Harold Ford. As I've reminisced in previous years, I was privileged to work with Professor Ford at Clayton Utes in the 1990s, where he was a much revered and extraordinarily generous with his time and wisdom. As a young lawyer, I was constantly amazed at his powers of recall and his complete mastery of not one but two extensive bodies of law in both company law and the law of trusts. A Herculean feat indeed. We treasured our association with Professor Ford and are very pleased and proud to sponsor this lecture. And we're profoundly grateful to Her Honour Chief Justice Kiefel for continuing the fine traditions of this event. So in closing, could I please invite you to join me in demonstrating our appreciation of the Chief Justice in the customary.